The 10th Amendment states that all powers not delegated to the national government are reserved to the states. In this lecture, we're going to look at exactly what those state powers are. The reserved powers of the states have not been written out, and perhaps never could be completely, but I want to give you examples of the sorts of things states are able to do. I'm going to start with things that are completely non-controversial. First, at the most basic level, states define and punish the vast majority of crimes. All the ordinary crimes that have existed for centuries, murder, assault, theft, and such things, are state crimes. Next, states provide most of the day-to-day public goods that citizens use in their daily lives. Local roads, schools, services like police and fire. Of course, a lot of these services are provided through local governments, cities, townships, counties, and the like. But these local governments are themselves chartered by the state and can be thought of as extensions of the state. If we want to simplify, in We the People we can usually treat Ann Arbor and Michigan as the same thing, while the national government is a different thing. It's also notable that states handle almost everything related to family law and property ownership. Now think about this list for a minute. An ordinary person going through day-to-day life is going to be far more impacted by these state-level policies than the national level. Think about the big events an average person might experience: learning to drive, graduating high school, deciding whether to abort an unwanted pregnancy, getting arrested for drunk driving, buying a house, adopting a child, getting divorced. It's all governed by state law. And yet state government is often an afterthought as we talk about politics. It should not be. A series of court cases in the late 1800s and early 1900s began to define the things that state governments are allowed to do. Here are three of the most famous. In Mugler v. Kansas, 1887, the Supreme Court held that Kansas was allowed to ban all alcoholic beverages. Notice that in order for the United States as a whole to do this, to enact prohibition, a constitutional amendment, the 18th Amendment, was needed. But a state, like Kansas, would have this power inherently. In Jacobson v. Massachusetts, 1905, the court said it was constitutional for a state to require mandatory vaccination. All residents who were medically able were forced to get the smallpox vaccine. In Village of Euclid v. Ambler, 1926, the court held that local governments could pass zoning laws. Today, we are used to zoning, but if you think about it, the idea that even if you own a piece of property, the government tells you what kinds of buildings you can and cannot build, say, a single-family house but not an apartment building or a business, you could see this as a severe limit on your right to own property, and yet the states can do it. How do these kinds of cases arise? In all three cases, the party challenging a use of state power is arguing that their personal liberties are being violated. Usually, they use the Due Process Clause of the 14th Amendment, one of the most important sentences in the whole Constitution. We'll spend plenty of time talking about the Due Process Clause later, but here it is. No state shall deprive any person of life, liberty, or property without due process of law. So, somebody makes an argument that the state is taking away their life, liberty, or property. Mugler argues that his liberty and property include the right to brew and sell liquor. Jacobson argues that his liberty includes the right not to be forced to take a vaccine. Ambler argues that the right to property includes the right to choose what kind of buildings to construct on the property you own. Now, in all three cases, the individuals in question lose. We can summarize this idea with the general term, the police power of the states. The police power is the power of the states to regulate behavior within their territory to advance their residents' health, safety, morals, and the general welfare. This is a different use of the word police than when we talk about the police as cops or law enforcement. We are using police in the sense of policing people's behavior. Again, this is unlike the national government, which, as we have said, can only act on its enumerated powers. The United States does not have a general police power. I want to read some passages from Jacobson v. Massachusetts, the vaccination case, because the Supreme Court wrote in depth about social contract reasoning in making its decision. This is Justice John Marshall Harlan writing. There are manifold restraints to which every person is necessarily subject for the common good. On any other basis, organized society could not exist with safety to its members. Society based on a rule that each one is a law unto himself would soon be confronted with disorder and anarchy. Real liberty for all could not exist under the operation of a principle which recognizes the right of each individual person to act regardless of the injury that may be done to others. In these words, I hope you hear echoes of Lockean philosophy. Justice Harlan is saying that safety, here protection against a dangerous disease, is one of the reasons why people would quit the state of nature and form organized society. And given that situation, we cannot let individuals opt out of following the laws, because that would return us to the state of nature. Mr. Jacobson's decision not to get vaccinated doesn't just affect himself, it could lead to a neighbor contracting smallpox. Justice Harlan continues, the possession and enjoyment of all rights are subject to such reasonable conditions as may be deemed essential to the safety, health, peace, good order, and morals of the community. Even liberty itself, the greatest of all rights, is not unrestricted license to act according to one's own will, it is only freedom under conditions essential to the equal enjoyment of the same right by others. So, a state government can generally do things to improve health, welfare, safety, or morals. However, the police power is not unlimited. As we learn more about due process, we'll see cases where individual rights, under the Due Process Clause, triumph over the police power. A famous example is Lawrence v. Texas, 2003, in which the court struck down a Texas sodomy law that made it criminal to engage in homosexual sex. Texas tried to argue that banning gay sex was a valid use of its police power. It made the argument that such laws were traditional, that homosexual sex had been considered immoral for hundreds of years. However, the court concluded that individuals had a fundamental right to engage in intimate relations in private. Texas's police power did not reach into the private bedroom. That's a basic introduction to the powers of the states. In the coming lectures, we'll be looking at national powers.